Washington State HR professionals, mark your calendars. Major employment law updates are coming between July and September 2025. From pay equity and wage transparency to new sick leave rights and layoff notification rules, these statewide changes will impact every employer, regardless of size. Let's break down what's changing, how it affects you, and what actions HR must take to stay ahead. Starting July 1st, 2025, Washington significantly expands the Equal Pay and Opportunities Act, EPOA. Originally focused on gender-based wage gaps, the law will now protect workers from pay discrimination based on any protected class, including race, age, marital status, sexual orientation, national origin, creed, color, citizenship or immigration status, veteran status, and disability. This means employees who believe they're being paid unfairly, not just due to gender, but due to race, age, or any other protected characteristic, can file complaints and seek legal remedy under state law. The burden of proof falls on employers to justify wage differentials using legitimate, job-related factors such as seniority, merit, education, geographic location, or quality of work. If a company's compensation decisions aren't backed by objective reasoning, they could be at risk of wage discrimination claims, civil penalties, and reputational harm. So, what to do? Conduct a comprehensive pay equity audit by June 30th. Review compensation data across roles and demographics. Update anti-discrimination policies and train all managers involved in salary decisions. Also effective July 27, 2025, Washington modifies its pay transparency law under SSB 5408. Previously, employers with 15-plus employees were required to disclose pay ranges and benefits in all job postings. Now, if the wage is fixed, such as a set hourly rate or a specific annual salary, you can simply post that fixed number. The law also protects employers from liability over job listings copied by external job boards without permission. Most notably, the update introduces a 5-business-day grace period, giving employers time to correct non-compliant postings before facing fines. So, what to do? Audit job postings regularly. If offering a fixed wage, list it clearly. Train recruiters and hiring managers to follow updated posting protocols. Effective July 1, 2025, SB 5104 strengthens protections for immigrant workers. It is now illegal for employers to use an employee's or their family member's immigration status to threaten, silence, or retaliate against them, especially when they assert lawful workplace rights, like unpaid wages or reporting unsafe conditions. The fines are steep, up to $10,000 per violation, and each instance of coercion counts. So, what to do now? Update anti-retaliation training. Clearly communicate to all supervisors that immigration-related threats are unlawful and can lead to severe penalties. Under HB 1875, effective July 27th, Washington expands the allowable uses of paid sick leave. Workers, including qualifying gig workers, can now use their accrued time off to attend or prepare for immigration-related legal proceedings involving themselves or a close family member. Employers may request reasonable documentation but cannot demand proof that discloses immigration status. What to do now? Add this category to your leave policies. Train supervisors to process these requests confidentially and without retaliation. On July 27, 2025, the new Mini-Warn Act takes effect. Any employer with 50 or more employees must provide 60 days written notice before mass layoffs, plant closings, or business transfers affecting 50-plus employees. The notice must go to employees, union reps if applicable, and the State Employment Security Department. Penalties include up to 60 days of back pay plus $500 per day per violation. Employees on state family medical leave cannot be included in these layoffs unless a narrow exception applies. So, what to do? Add mini-warn protocols to your layoff and restructuring playbook. Create draft notices now. Notify leadership of these new notice obligations. Last but not least, under HB 1308, Employees, current or those separated within 3 years, can request a full copy of their personnel file, and employers must comply within 21 calendar days, free of charge. The file includes applications, evaluations, payroll records, disciplinary notes, and more. Employees may also request a signed statement explaining their termination. Non-compliance can lead to lawsuits, with fines ranging from $250 to $1,000 per violation, plus attorney's fees. What to do? Centralize file storage and access protocols. Train HR staff to handle requests quickly and legally. Use templated response forms to ensure consistent compliance. Between July and September 2025, Washington's HR compliance landscape changes dramatically. Now is the time to prepare. Revisit your pay structure, refresh job postings, update leave and record-keeping policies, and make sure your team knows the rules. Taking proactive steps now not only helps avoid costly penalties, it helps you build a legally sound, ethically grounded workplace. Subscribe to Amorit Education to get the latest HR compliance updates delivered straight to your inbox.